Chisholm, attorney for Shelby County. I represent Kelvin Montgomery in this matter. This time I would request 2 minutes of rebuttal.
All right, Mr. Chisholm, you know we're using our light system now, so just pay attention to the color of the lights. That'll keep track of the time, and I will try to give you appropriate signals as you wind down.
Yes, thank you, Your Honor. In my brief, I think I briefed approximately 4 issues. I'm going to start off with issue number 2, which is the plain error issue. It's our position that the trial court did commit plain error by failing to give a white instruction in connection with the aggravated rape count. Now, again, this was not objected to, not put in the motion for new trial. However, this does rise to plain error, is our position. First of all, the record's clear. No white instruction was given. That is a breach of a clear, unequivocal rule of law. Doesn't look like a tactical reason. I don't know why a lawyer would not want a white instruction. That makes it harder for the state to convict your client. So that boils down to whether a substantial right of the accused was adversely affected and whether it's necessary to do substantial justice. Now, I acknowledge it is my burden to prove plain error. The state was correct in its brief when it noted that I kept saying the state has to prove beyond a reasonable doubt. You know, that's the standard on direct appeal. The state, if this was raised on direct appeal, plenary review. But in this case, I do have the burden. But I would submit, even though it is my burden to prove plain error, I think I can ask the court, I can make the argument that, hey, the reason I can show it's plain error is because the state can't show it's harmless beyond a reasonable doubt. I'm going to throw that out there as I think that's a legitimate way to argue plain error. If the court disagrees with that, however, I think I can ask the court to say, I can say this court cannot conclude that this is harmless beyond a reasonable doubt. That way I'm not really putting it on the state. I'm saying, hey, I'm proving a substantial right was adversely affected because this court can't conclude it's harmless. I like to keep that harmless beyond a reasonable doubt standard if I can, since this is a constitutional issue. However, if the court disagrees with me there too, then I'm stuck with what the case law seems to say, State v. Kelvin, which is I have to show this more probably, what's the exact language here? I want to get this right. Probably affected the outcome. I have to show that. And I think in this case I can show that this probably affected the outcome. The reason I can show that is if you look at the facts of this case, from the point of the half-shell restaurant to the time that the defendant and the victim got to the defendant's home, that period of time, I would submit, a reasonable juror would not have found that that was a kidnapping. The defendant, of course, testified none of this was a kidnapping. Or, he said it was all consensual. But even if we look at the state's version of the facts, Natasha Huggins, who was the friend of the victim, co-worker at the half-shell, she talked about the victim and the defendant kissing each other at the half-shell, so we have all that. Then Ms. Huggins said that the victim 2 times asked her, hey, you want to go to the Fox and Hound with me? So the victim was talking about going to the Fox and the Hound even at the half-shell. Natasha Huggins testified that while in the defendant's truck, the victim again was talking about going to the Fox and the Hound, saying, yeah, I'll see you all over there. Now, it is true, Ms. Huggins testified the victim could barely talk or move, was very intoxicated. I do acknowledge that, but nevertheless, she's still talking about going to the Fox and the Hound there, according to Ms. Huggins. Ms. Huggins never called the police when they drove off. It seems like if she really felt this was a kidnapping, she would have called 911, or she never followed them over to the Fox and the Hound. Seems like she would have done that if this was truly a kidnapping. Her husband, Christian Huggins, also never called 911, never followed them over there. The victim said she could not really recall kissing and hugging the defendant at the half-shell. And she said that she did agree to go to the Fox and Hound, but she was under the impression her co-workers were going to be there. I think she said the defendant told her they're going to be going to the Fox and the Hound. Victim says she could not move her arms or legs, did not want to be in the truck, attempted to tell Natasha she did not want to be there. But I don't think there is ever any proof in this record that the victim said she turned and told the defendant, I do not want to go with you to the Fox and the Hound. Honestly, what I think that how the jury would have perceived this is the victim, Natasha Huggins was upset with the defendant. They had gotten into it, and she didn't like the defendant. And she ran out there and didn't want the victim to go with the defendant. But the reason I'm going into such detail on this is because that's the first stage from the half shell to the Fox and the Hound. And if I can establish that this was such a, the proof as to a kidnapping was so weak here that the only, and I'm kind of jumping ahead of myself, but the reason I'm doing this is because I'm asking this court to consider that the only possible kidnapping that occurred really was when they got to the bedroom, and at that time, if we accredit the victim's testimony, the defendant attacked her and confined her and sexually assaulted her. And that all happened in one episode where a jury, had they been properly instructed, could have concluded that this confinement was incidental to the well, if she was acquitted of aggravated rape, so it would be the aggravated sexual battery, that it was all incidental. Because if the proof was strong that he kidnapped her at the half shell, I wouldn't be able to really make this argument, because then this court would say, well, this kidnapping happened hours before they got to the bedroom. But what I'm trying to establish is that the proof of the kidnapping was extremely weak, and I'm saying even non-existent, from the half shell to the Fox and the Hound. So let's look at the Fox and the Hound back to the defendant's house. Let's see if we have a kidnapping there, because that could possibly throw me out of the water if this court concludes he kidnapped her an hour, 20, 30 minutes earlier than they got to his house. But again, there's no proof of that. Again, the defendant said it was all consensual. She told him, hey, I'm going home with you, because he said he wanted to drop her off back at the half shell. She said, no way, I'm coming with you. Again, that's his side, which I submit was credible. Now, we look at her side. She said that after they got at the Fox and the Hound, or after they left there, he said he's going to take her by his house a minute. She testified she did not want to go, but she never, in this record, I don't think this court's going to ever find where she told him, I don't want to go to your house at that point. Now, I think earlier in the night, he was asking her to come to his house, and she got offended. I'm not going home with you, but we're talking about after they've been hanging out, kissing, drinking together for several hours. I don't believe you're going to find in this record her telling him,
Do I have to tell someone I don't want to go somewhere in order for it to be a kidnapping?
I think that in this case, there was no evidence that he forced her from the Fox and the Hound back to his house.
Well, but if he said I was giving her a ride from the Fox and the Hound back to the half shell, that's his testimony.
Correct.
And her testimony is he was giving me a ride. I wanted a ride from the Fox and the Hound to the half shell, and he drives to his house. Well, does she have to, somewhere between his house and the Fox and the Hound, say, I don't want to go to your house, even if he's not telling her that's where they're going?
I think if it's going to sustain a conviction of an aggravated, some type of kidnapping, there has to be some proof, because
What element in the statute says that there has to be lack of consent? It's not, we're not talking about the rape, we're talking about the kidnapping.
I understand, Your Honor, but I'm just saying her just consensually going with him, and there's no proof that he's forcing her to go to his house. She was riding in the car. They walked out there
She's
together.
supposed to jump out of the car?
Well,
I mean, she's clearly highly intoxicated. It seems to me, I understand your argument, but it also seems to me you're putting a lot of burden on the victim to avoid being the victim of a crime, as opposed to the individual who's carrying out the kidnapping. And,
I mean,
and let's, I mean, it is a kidnapping, but I mean, he's confining her to his car, and he's driving, and unless she wants to jump out of a moving car, she doesn't really have a choice, does she?
I mean, I see the court's point, obviously. Intoxicated, he's taking her with him. But that could also be her, at first he's going to take her to the half shell, and then he says, no, we're going to my house. Based on this record, I mean, I know she said she didn't want to go, but if she's not communicating that to him, I'm just thinking maybe he, in his mind, thought, okay, she's cool with that,
Okay.
going to the house. I mean, I'm just submitting.
I understand your argument. I guess the last question I have on this, though, isn't this what the jury determines? I mean, he testified, here's what I was going to do. She testified, here's what I wanted. I didn't want to go to his house. That's a jury question, is it not?
It is, and for sufficiency, I could understand, my burden is a lot higher there, but as far as this white instruction,
Your burden's higher with the plain error instruction,
well,
with the plain error question.
I would submit that if you look at a lot of the white cases, they talk about, the ones on direct appeal say, look, if this evidence could be interpreted several different ways, we're going to reverse if you didn't get a white instruction. In this case, this evidence about whether or not she wanted to go to the house, didn't want to go, it's susceptible to different interpretations. It's not a slam dunk kidnapping. And that's the reason I'm arguing that's so relevant to this analysis on plain error, on the white instruction. So, and then also, really, her testimony is the only evidence we have that she did not want to go from was it the Fox and the Hound to his house. If you look at the officer, the nurse, and the other officer, their testimony is very important here because they all interviewed her shortly after the crime, and she said to Officer Charles, yeah, we went to the half shell, met a male white there, began talking. Then we went to the Fox and the Hound, had some drinks. Then we went to his house. Nurse DeCenza said, yeah, the victim told me they met at the half shell, had a couple drinks, went to the Fox and the Hound, drank some more. Couldn't recall much what happened there. Then they went to his house. He asked her to come in the bedroom, which she did. So, and I'll just say Burke too, same thing. Drinks the half shell, Fox and the Hound, drank some more. Victim then said she went back to the defendant's house. He asked her to go in the bedroom. She did. So this even muddies the waters more about reasonable interpretation about what happened because none of them say, yeah, she told me he kidnapped her at the half shell and then dragged her to the Fox and the Hound and took her back to his place. Those are three witnesses right there summarizing what she told them. Respectfully, I think that the only possible proof of the kidnapping would be if this court accredits her testimony at the house, and that all happened in one episode, the aggravated sexual battery, the confinement. That's why a white instruction had to be given right there. It was given for the attempted murder and the kidnapping, but for some reason wasn't given on the rape and the kidnapping. The state cites this Hulse case, H-U-L-S-E. They found harmless error, but there the defendant it was either assault or rape. That happened, and then she ran out of the house. He chased her down, and they said, well, he had already completed the assault or rape. Then he's chasing her and grabbing her. So I could see where that would be harmless. Those are that is an assault followed by a kidnapping. So that's not what we have here, is my position. The next issue is the sufficiency of the evidence. As I argued in my brief, and I submit no reasonable juror could have accredited the victim. The defendant's testimony was much clearer. I know the state's arguing that was a jury question, and they resolved that discrepancy. I stand by my argument, but I will say this. Even if this court concludes the victim was credible, no evidence of serious bodily injury in this case. No reasonable juror could have found serious bodily injury. Let's go through the factors. No substantial risk of death. I think Nurse DeCenza said after 2 minutes you can die of strangulation. We don't have proof that this lasted. We don't really know how long it lasted, quite frankly.
Well, didn't she pass out?
She said that when she first went in the room, he started walking at her with the handcuffs. and everything went dark. Now, that right there, we don't know, it's hard to say why it went dark. I don't think she specifically said he hit me there. I think that can be inferred, I guess, but maybe she passed out from the alcohol or something. I mean, I was reading that this morning coming over here again. That part, I don't think she specified what made her pass out at that point. So the state's arguing, well, look, you know, she passed out long enough to have all her clothes taken off and wake up being handcuffed and him having sex with her. That had to be a substantial, you know, protracted loss of consciousness. But again, we don't know exactly why she passed out, and even so, we still don't know how long it took. It could have been brief. Someone could take someone's clothes off very, you know, it doesn't take that long, I would submit. And the case law is very clear that it has to be protracted. I hit the Westlaw this morning a little bit. I'd like to give the court a couple cites. State v. Ernest Pyle, and I can do a letter if the court wants me, but these talk about this issue. 2014 Westlaw 5513041. And there, the victim woke up in a different part of the room than she had been in when she lost consciousness, and that injury she did not know she sustained. Testified she did not know how long she was unconscious. She was unable to determine how long unconscious. Did not say it was brief, though. That's Pyle. So she woke up in a different room. And then
Okay, that Westlaw site, 2040 Westlaw 5513041.
2040 Westlaw 5513041.
All right.
And then Ronald Carroll, State v. Ronald Carroll, 2014 Westlaw 1759101. The victim was attacked in a parking lot, woke up in a hospital 2 to 3 days later. They said that's obviously protracted unconsciousness. State v. Bill Naramore, 1995 Westlaw 10337.
These are just cases that you're adding to the cases in your brief?
They are, Judge. You know, after preparing, seeing the state's argument and everything, I went back and researched a little more, you know, as I was preparing. These are, I guess the reason I probably didn't cite them the first time, they seemed so, it was a lot longer unconscious than in my case. But I want to throw it out there. 1995 Westlaw 10337, that's Naramore. And then Neblett, 2012 Westlaw 4841322.
Okay, so I'm going to ask that you
It's just
submit a
4.
letter, Mr. Chisholm, if you don't mind, because you're giving me at least 5 cases, and I'm
Yeah.
I'm feeling like I'm trying to write them all down. I would prefer just a supplemental letter with authority if you feel it necessary.
Yes, I will. I do
Yeah.
think that's going to be helpful for the court. But as far as the aggravated sexual battery, they acquitted him of the aggravated rape. She never testified specifically about him touching her in a sexual manner. In other ways, the state's asking us to say, well, he must have touched her breast if he's lying on top of her. I'm not sure that gets us to an intentional touching of an intimate part, intentional touching for, you know, sexual purposes. I would submit there's not sufficient evidence for aggravated sexual battery. I see my time coming down to 10 seconds. Sentencing, I mentioned about the SN victim telling the prosecutor what happened, and he summarized it for the court. I stand by, I know the court, that wasn't testimony, that was him summarizing. I don't know if, I've never seen that before. I don't know if trial courts are allowed to give weight to when a prosecutor summarizes what a victim said happened. I acknowledge courts consider uncharged, you know, conduct that did not result in convictions, but, you know, he summarized what SN told her had happened in, you know, down in Alabama. It's all on the record, and I know the courts read it, but.
I'm sorry, your time is up, but I thought she actually testified at some point.
SN did testify about that he has caused her great, you know, emotional distress, but she never got into the facts specifically about what happened on the boat and the rape that he committed against her and all that.
All right.
So I've just never seen where, you know, the state's trying to use another incident, but they don't put on actual testimony, or they kind of summarized it. And I just wanted to point that out. And then lastly, on enhancement factor 8, I noticed in the pre-sentence report, the VOP was dismissed, a violation of probation. The state's trying to use the VOP as one to meet factor 8. I just want to point that out, that it looks like it was dismissed. I don't know if that's properly used that or not. And I would ask the court to reverse and remand, or either reverse and dismiss.
Thank you so much, Mr.
Thank you.
Chisholm. Okay. Okay, I'm going to ask the indulgence of the state again. We need to take one more break. Apologies. Thank you. Yeah, yeah, I've seen that. Must be doing other sections. Oh, okay. Cool. Always want to get over there and party in the east or something, do something different. Yeah. Tired. Well, then you, the list. This is one where I think there's enough for both people. Or it'd be interesting to see how it goes. I think when it's something already, here lately, I think it's stuff written on it. At least here, it's like, oh, good, that's what I want to construction. Good. Yeah, it is, you know. Haven't had a white issue in a long time. It's kind of like that. I used to do that a lot. 2007 through 2010. Seems like every brief I had, I tried to get my hand and stuff. I just got tired of it, so when they changed the law in 2012, good, it's not already anymore, the jury decided that, you know. Of course, there it is again. Those convictions and appeals, we kind of made that good. I started the last 2 years, I started doing trial work. Started appointing regular cases, so I haven't been, they come off my appeals, you know. And yet it's been like, they called me one the other day, first time I ever told them. 1 year, I've just been so swamped doing a lot of trials for them. Man, I can't, this appeals take a lot of time, so it's so good. Right, it really is. I think I'm trying to trial stuff.
All right.
Thank you, State.
Good afternoon,
Thank you.
Your
Good
Honors.
afternoon.
Abigail Renard for the state. This court should affirm the defendant's convictions. First, the defendant waived his challenge to the jury instructions and cannot establish plain error. Second, the evidence showed that the defendant took the victim into his bedroom, removed her clothes, handcuffed her, and brutally assaulted her, leaving her with significant injuries. This evidence is more than sufficient to support each of his convictions. And finally, the trial court properly exercised its discretion when it imposed consecutive sentencing and within-range sentences after finding that the defendant had an extensive criminal history and was a dangerous offender. So first, I'll address the White instruction. This issue is waived, as the defendant acknowledges, and he's not entitled to plain error relief because he cannot show that consideration is necessary to do substantial justice. So first, there was a White instruction in this case. It was admittedly given for the first-degree murder and not the aggravated rape, but it was still given. The jury still had that information.
Well, you're not saying that they could use that on the, what was the charge of defense that resulted in the axe expat?
It was aggravated rape was the...
Yeah, you're not saying that they could use the white instruction that was given in conjunction to the first-degree murder with the Ag's bat.
No, not necessarily, but it's still there, they're instructed on all of the offenses.
No, they're
There's-
not, because you're specifically supposed to include which offenses they're supposed to
Correct,
consider.
yes, I agree with you completely on that, Your Honor,
Okay.
yes. But nonetheless, they were still instructed on the specific elements of all the offenses, and they were properly instructed otherwise. And there was the white instruction with the first-degree murder, admittedly not with the
Well, those, I mean, you
aggravated
really,
rape,
go ahead. I mean, it is of no use to you with this argument, in my view, because it wasn't charged in conjunction with the offense of conviction.
Correct.
So, I mean, I'm not saying that it's reversible at this point, but that's your problem. You're operating under plain error, and you've already conceded that, you know, it was an error, basically.
Yes.
So you may proceed.
But in addition, outside of all of that, the evidence here showed that her confinement was longer than necessary for the aggravated sexual battery. You know, we can go back and forth all day about what happened at the half shell and between the half shell and the Fox and the Hound. And none of that really matters for the initial part of that, even if she was drinking with him and chose to drink with him, that doesn't impact what happened later in the night. And at some point they're in his truck, and I believe she testified that while they were at the Fox and the Hound, she wanted to go home, and the defendant finally agreed to take her home. And then they get in his truck, and she testifies that she realized they were going the wrong direction and she was in danger. And at that point, if not before then, it's possible that the unlawful confinement began before then, but certainly by that point,
What did the state argue at trial?
that was when she
That was when it started?
I believe so, if I remember correctly. That was the unlawful confinement began there, and then he takes her to his house. She doesn't want to go inside. She very clearly testifies that she doesn't want to go inside, and then she finds herself in his bedroom, sitting on his bed, and he brutally assaults her. And then he handcuffs her and keeps her handcuffed throughout the assault, and then after he stops assaulting her, there's also a period where she's still handcuffed and waiting for him to go to sleep. And it's not clear how long that is, but there's certainly a period where he's not assaulting her, where she's terrified, laying in bed, waiting for him to go to sleep so she can escape. And then when she eventually does and gets out the door, she's running down the street, still handcuffed, still has a ball gag around her neck, and eventually is able to get help. So this certainly establishes unlawful confinement beyond that which is necessary for aggravated sexual battery. And again, this is plain error, and consideration of this issue is not necessary. Turning to the sufficiency issue, the evidence here was more than sufficient. So first, the defendant's arguments are primarily a challenge to the victim's credibility, and this court does not reweigh the evidence, and credibility is determined by the jury. And the jury had every reason here to discredit the defendant's version of events. He acknowledged on cross-examination that he disagreed with most other witnesses who testified, including those who testified in his defense. He claimed that her neck injuries were hickeys, that she had some injuries that looked like acne, and that her injuries were caused by flopping off the bed onto a tile floor. And then her testimony was well supported by the evidence of her extensive physical injuries. The expert in the state's case and the officer testified that her injuries were consistent with strangulation and with her story. And the injuries were certainly not established serious bodily injury and a substantial risk of death here. Again, the defendant was choking her repeatedly. She was in and out of consciousness throughout this entire assault. And the state's expert testified that strangulation can cause unconsciousness in 10 to 15 seconds and death in 2 minutes. And this court has found serious bodily injury in very similar circumstances. Similarly, for the aggravated sexual battery, there was sufficient evidence to establish unlawful sexual contact here. I think it's important to note that there's nothing in this record, aside from the defendant's testimony, that would suggest that this encounter was in any way consensual, certainly once they get back to his house. And the victim here testified that he removed her clothing, was on top of her, and necessarily that includes contact with intimate parts. She did testify that he repeatedly penetrated her vagina. Again, the jury did acquit on or convict of the lesser included charge, but regardless of what they think exactly happened, there's more than enough evidence here for them to infer unlawful sexual contact. And finally, to address the sentencing, the trial court did not abuse its discretion here. As the defendant concedes, the trial court properly applied the first enhancement factor for his criminal history and prior conduct. And that single enhancement factor allowed the court to impose the maximum sentence on both of his convictions here. And then the court also applied additional enhancement factors to the aggravated sexual battery and properly applied those. And to the extent there was any misapplication, that doesn't provide a basis for reversal because the court properly applied at least one enhancement factor to both of those convictions. And finally, for consecutive sentencing, the trial court properly found that he had an extensive record of criminal conduct. His criminal history began in 1977 and continued through this case and after this case. It was increasing in violence and frequency. He had multiple, to be sure, like a lot of his early convictions were more minor, but then it increased in frequency through this case and after. And if this court has no questions, we ask that you affirm. Thank you.
Mr. Chisholm, you have rebuttal.
May it please the court. To answer the court's question about what the state argued, my memory is they argued that the kidnapping started in the parking lot of the half shell. That's my memory of the record.
Okay, thank you, Mr. Chisholm.
And as far as the argument that the jury was instructed on White for the attempted murder, I 100% agree with the court that that's irrelevant to the issue at hand. I would reiterate, we had 2 officers and Nurse DeCenza who summarized what the victim told them shortly after the alleged crime, and the way they described it, it did not appear to be a kidnapping up until the point of the attack inside the defendant's house. I respectfully submit. As far as her lying there while he's sleeping after the sexual assault, I guess the state's trying to argue that's more confinement that went beyond, but I would submit that it's not. I mean, I would submit if he's asleep, I'm not sure they can argue he's still confining her at that point. So I think the White instruction was definitely, we've proven we were entitled to plain error on the White instruction. Briefly, I want to hit on the serious bodily injury. I got so caught up in my sights, I forgot to hit all 6 factors. I got through 3 of them, but I think the brief covers, no protracted disfigurement. It was bruising and scratches, essentially. Physical pain was not extreme. And then the only arguable one, she said that she has nerve damage, I guess based on the cuffs being very tight on her arms, her wrist. As I argue in the brief, I don't think just throwing out, she said, nerve damage, and not a whole lot of explanation about what the nerve damage was, the extent of it. I don't think that meets substantial impairment of function of bodily member. And my brief speaks to all that. I see my time's, I'm down to 8 seconds here, it looks like. So again, I would ask the court to reverse the convictions, and thank you.
Thank you, Mr. Chisholm.
Yes.
Thank you to both the state and Mr. Chisholm for your accommodation.
Thank you.
We'll take the matter under advisement. I think that concludes all the cases on the docket. I